Number 9. June 8, 1999 police report filed by June Murata concerning false allegation of my sons and I breaking into her house, already discussed in Divorce Diaries videos 2 and 3. The entry in Bartholomew's assessment includes this statement. There was a police report regarding a 6/3/99 incident in which Mr. Paige was alleged to have done some damage to his in-laws' home, but which, according to a recent fax, was dropped, so it wasn't processed. It was too processed, and it was found that June Murata, my ex-mother-in-law, could not substantiate her allegations against me. In other words, she had lied under oath, and her case was dismissed, not dropped. Again, Bartholomew either couldn't find the necessary paperwork or refused to even look for it due to time constraints. Number 10. Rebuttal argument to all allegations as stated by Leslie Paige in her no-contact order filed on 6/11/99. This refers to my June 16, 1999 Robert Paige declaration to Leslie's no-contact order court papers, which contain all of the discussed information with the same cited information. Number 11. Rebuttal summary report referral Child Protective Services to referral ID 998377 from Robert Paige. This refers to the December 10, 1999 CPS report that I filed to speak to my wife's May 13th, actually 21st, 1999 CPS report, in which I included these same evidentiary documents that Bartholomew already had and my summation of events that disproved all of the allegations that were submitted by my ex-wife, Leslie. To all of this information, Bartholomew makes the following statement in his assessment. Another curious quality is the obsessive quality of his paperwork. True, there are consequences to this evaluation, and thoroughness is helpful in these situations. However, he appears to go over the same material again and again. He appears preoccupied with the issue of the relationship between his wife's parents and his wife, with certain issues with the children, which occur in a stereotyped or repetitive manner. His preoccupation with detail appears to interfere with seeing the big picture, also a trait associated with offender populations. What he fails to mention is that all of these documents were filed in different places, and of course, since all of these places contain the same false allegations against me, i.e. the 5/21/13, 21/99 CPS report, the 5/21/99 Fairfax Hospital report, the 6/11/99 no-contact order filed by my ex-wife, Leslie, the 6/11/99 no-contact order filed by my ex-mother-in-law, June Murata, the 6/28/99 Pinedo letters, the 5/21/99 Overlake Hospital report, the 12/10/99 CPS report, and on and on. They were obviously going to contain the very same evidentiary documents. So when I presented him with these very same documents, they were exactly as they were when I filed them with these various places. It's interesting to note that he fails to speak of the redundancy of the very same false allegations being mentioned in the documents filed by my ex-wife and ex-mother-in-law. And finally, number 12, June 24, 1999, Myrna Pinedo PhD letter, already discussed in Divorce Diaries Video 5. He was referred by Dr. Myrna Pinedo, who had been seeing the family after Mika's recent suicide attempt. In this document, he rebuts Dr. Pinedo's letter, stating, the letter itself, as you read it, is full of rumor, conjecture, and speculation, based on second and third-hand information stated by my wife and her family members, who neither saw any of the claimed situations that they had stated against me, or completely made up the allegations in an obvious attempt to smear and discredit my name and my reaction of disbelief towards these allegations. This rather vituperative flavor is a consistent part of his responses to allegations. He goes on to attack her writing style. Her, Dr. Pinedo's, obvious conclusions are based on the fact that she found my wife and her family members' comments more credible than my perceptions, which in fact is a legitimate use of professional opinions. In fact, upon reading the letter, the evaluator finds that the bulk of the descriptions of Mr. Paige were either based upon or substantiated by Dr. Pinedo's first-hand experiences of Mr. Paige during sessions. For example, his statements about his in-laws and his derogatory comments about the writing style employed in Dr. Pinedo's letter. This type of vituperation is seldom encountered outside of abusive individuals, since it is in and of itself a form of abuse. In response to Dr. Pinedo document, where he goes on with what appears to be rather damning descriptions of her actions, and her intent, using such words as conspiring behind my back, constant interference, my wife's disallowance of letting me speak with our daughter, and similar descriptions. As already discussed in Divorce Diary Video 5, unlike Bartholomew's conclusions concerning the Pinedo letter written on my ex-wife's behalf, he goes out of his way to convict me of being DV based on the same second and third-hand information, along with their spurious statements against me. Please remember, in the Marcia Hedrick's PhD GAL report, when presented with the very same evidence, she stated, when pressed to corroborate these allegations, Leslie was not able to supply any credible evidence. This pattern suggests problems with judgment and credibility. As to why Bartholomew would make such outlandish statements against me, it later came to my attention by two other DV counselors, John Plummer, MSW, and David Vandergrift, MS, of the personal relationship and social bonding that Myrna Pinedo, PhD, and Doug Bartholomew, MSW, shared during this time period. As noted in his own contract that was given to me on July 7, 1999, during an initial appointment with him to gain an understanding of how he works, to discuss how he approaches his DV counseling service, and to go over and receive his contract, and then signed and presented to him on July 14, 1999 by me during our first contracted session, it states in the second paragraph, a civil court domestic violence evaluation consists of 2 one-hour sessions with you, an interview with the other party involved, possibly brief psychological testing, a review of records, and consultation with your attorney prior to writing up the evaluation. In looking through his billing statement, he lists 3 meetings. The first listing is listed as being an individual meeting where, as I already discussed, it was to gain an understanding of how he works, to discuss how he approaches his DV counseling service, to go over and receive his contract, to discuss his fees, $100 per hour for his required 2 one-hour sessions, to establish whether or not I meet his requirements to be treated by him, to receive his standard contract for me to fill out and return by the first interactive diagnostic session, to receive several release forms of counselors, physicians, CPS, police reports, etc., that he deemed necessary to have when making his final report, and to inform me that he charges $560 for his final written evaluation. July 14, 1999 interactive diagnostic meeting, which turned out to be the only interactive diagnostic meeting, the following took place. At the beginning of this meeting, Bartholomew admitted to me that he had not yet read through any of the information that I had presented him with on July 7, 1999, during our initial appointment, where he determined what kind of guidance he was going to confer upon me, and that he was not going to read through any of it until he had his question so that he could determine on what level to base his assessment on, which he did not receive, the question, until August 6, 1999, as mentioned in his own report. His lack of knowledge became quite obvious after we began to record this session when, as he put it, I appeared to become physically agitated, thinking about the behavior of others, and appeared to become angry just sitting in the interview room, when in actuality, my anger was at him for my continually having to correct him on which family members I was speaking of, how they fit within the family dynamics of this situation, and especially when I had to help him understand when I was attributing information that concerned my parents versus my in-laws. He was continually getting them backwards, which was very frustrating. The August 12, 1999 alleged interactive meeting, on the day I thought I was supposed to have my second contracted meeting with Doug Bartholomew to do his final interview evaluation of me, to my surprise, he hurriedly gave me a copy of his written evaluation. Please note, according to his own report, he had completed it the previous day on 8/11/99. He had me sign that I had received it and told me that he had no time to discuss or go over it with me. His hurried response seemed to be due to the fact that on that same day I had received a letter from Dr. Johnson, my daughter's pediatrician, verifying that I never molested my daughter. When I told him of this, he became very agitated and refused to talk with me. After reading an assessment of me after I left his office, it is understandable why he reacted this way. Throughout the month of September 1999, I tried to make an appointment with him to go over his assessment and to discuss another assessment of me done by John R. Plummer, MSW, of the Family Services Domestic Violence Treatment Program, where he found on 9/2/99 that I did not meet with the profile of a DV person. His response on the phone to me was that Mr. Plummer's criteria was different than his. We were unable to come to a mutual meeting time because I was unable during the morning hours due to my work schedule as a public school teacher, and he could not meet with me after 4 p.m. per my request because, as he stated to me over the phone, he doesn't work after 4 p.m. Interesting note, during the past 7 months when I was counseling with his associate David Vandergriff, MSW, there were many evenings when I observed Doug Bartholomew working well past 7 p.m. Also, as you look through his billing statement and his assessment under interviews, there are no listings of either an interview with the other party involved, possibly brief psychological testing, or a review of records and consultation with my attorney prior to writing up his evaluation. Here is the entire assessment as written by Douglas Bartholomew, MS, to read through. Please keep in mind all previous concerns as mentioned here. I would like to point out one more entry to everyone who is watching this video. That is the opening disclaimer, which states, this assessment is not a complete psychological evaluation, but a summary of information obtained in an interview or series of interviews as described below. Any representations made in this assessment are for the purpose of assessing risk, recommending a treatment plan or further interventions or evaluation for the benefit of the client or others potentially affected by their behavior as may appear appropriate at the time of the interviews. No conclusions can be represented about whether or not the client would benefit from treatment. Furthermore, no statements can be represented as an indicator of the truth or justification as to the facts of any charges or accusations which may be pending against the client. Nor can any statement be construed as an accurate representation of the character or history of the client. The comments in this assessment cannot be used in any way, shape, or form in a criminal case. By accepting this report, the user is agreeing to not present or represent this report except in total form, without editing and without presenting, reading, or discussing any plan of it out of the context of the entire report. Doing so is grounds for revocation of the report. As you read this, you can only conclude that this disclaimer in and of itself, as written, disqualifies it as being a credible opinion of whether I am DV or not. This was also the opinion of Hedrick's in her 07/31/2000 GAL report and the King County Superior Court in our 08/13/2000 final family plan when they deemed this report inconsequential. Regrettably, though, was the fact that from the filing of this report with King County Superior Court on 07/14/99, coupled with a Myrna Pineno PhD letter filed on 06/28/1999, the court stated to me that if I was to even have supervised visitation with my two sons, I would have to attend the DV class for the year that it would take for the GAL report to be completed and filed before they would write up my final visitation plan in our family plan. When viewing the text of this assessment, feel free to pause the video if you wish to read it word for word as each of the 6 pages is presented. On October 21st, 2000, I did file a complaint with DSHS, Department of Washington State, which did include all of the documents, letters, and findings previously discussed in this video. The response letter that I received stated the following. After careful consideration of the information you sent, the Secretary of Health has determined not to pursue disciplinary action against Mr. Bartholomew's registration and/or certification to practice as a counselor. The closure of a complaint in no way indicates that the complaint filed was without merit. The Secretary of Health has limited investigative and financial resources for the pursuit of complaints against health care providers. The Secretary of Health may reconsider a complaint which has been closed only if additional relevant information is received. In the ensuing years since I first filed my complaint concerning Doug Bartholomew's assessment of me to DSHS, and after hundreds of similar complaints were filed by other fathers in similar divorce actions with KCSC that were also assessed by Doug Bartholomew, DSHS on February 6, 2013 finally filed a test case against him, case number M2011-1023. The charge in being that, number 1, risk assessment of Client A was below the standard of care. Number 2, the risk assessment of Client A contains the grammatical and sentence structure errors. Number 3, reverse pronouns so that the sentence stated the opposite of what Client A represented to respondent. Number 4, incorrect usage of pronouns. Number 5, the risk assessment contains statements and quotes attributed to Client A that are not supported by the clinical record. Number 6, misquoted Client A. Number 7, respondent's risk assessment of Client A is unprofessional and biased. These allegations resulted in the DSHS ordering 3.1. Commencing with the effective date of this stipulation, respondents shall no longer accept domestic violence-related cases for the purpose of conducting domestic violence evaluations and/or testifying as an expert witness. Within 6 months from the effective date of this stipulation, respondents shall complete or refer out any such outstanding cases. 3.2. Respondents' credential to practice as a mental health counsel in the state of Washington shall be monitored for at least 2 years, commencing on the effective date of this stipulation. 3.3. Respondents shall reimburse costs of the program in the amount of $65,000, which must be received by the program within 2 years of the effective date of this stipulation. Upon further investigation, on March 1, 2013, DSHS stipulated that outlined in this agreement, DVPT provider Doug Bartholomew, MSW, must pay a substantial fine to the DOH, restitution to his victim, subject himself to multi-year supervision by the DOH, refrain from ever conducting another domestic violence evaluation, and he will never again represent himself as an expert or testify in a courtroom. In his closing arguments of Doug Bartholomew, Judge Michael J. Fox stated, Mr. Bartholomew's analysis, fact-finding, and conclusions are not what this court has a right to expect from one who presents himself as an expert in domestic violence. He seems to move from a predetermined result to a preconceived conclusion. His report is sloppily written, his logic weak, and his assessment rife with inconsistency and bias. I find this an absurd conclusion to advance in a domestic violence risk assessment. Mr. Bartholomew is not a psychiatrist and has no professional credential or expertise which would qualify him to opine on what events cause any psychiatric symptoms. Bartholomew's testimony and report is carelessly put together despite making very serious findings. This assessment that he performed was a forensic examination, and we have standards for the performance of forensic examinations. Yet this last conclusion is precisely the type of conclusion that our rules of evidence, particularly Rule 404, forbids. In 22 years on the bench, I have never reviewed an expert report such as this. It is internally inconsistent, not at all neutral, and so sloppily drafted that the author never even proofread it, as he admitted. Consequently, I give no credence to the Bartholomew report. Even though this represents some form of reparation and offers some consolation for myself and all the fathers that Doug Bartholomew falsely accused of being DV, it does little to make up for all the lost years and time I could have spent with my daughter, Mika. To see the complete record and findings by DSHS concerning Doug Bartholomew, please visit the Superior Court Judges Association at the following web address: http://superiorcourtjudgesassociation.com/. Thank you very much for watching my video.